Now on our Ag Issues program this morning, it is our regular visit with Roger McEowen, the Kansas Farm Bureau professor of Ag Law and Taxation at the Washburn University School of Law. Good morning, Roger.
Good morning, Kyle. How are you this morning?
Doing okay. Much cooler conditions here as we talk about a topic that might get things a little hot from time to time, given its many complexities and intricacies. Fence law in Kansas, and it seems that when we talk about fence law, as we said, it can get quite dicey at times.
Well, I tell you what, Kyle, I spend a lot of my time dealing with tax issues and estate planning, business planning. And so outside of those issues that I deal with and the calls and the emails and all of that, I would say next on my list would be fences and then leases. And maybe not in that order, but it's a big issue in terms of the things I deal with on behalf of people.
Now, what are some of the most common issues, most common questions that are brought to your attention when it comes to the state's fence law?
Well, I'd say a common question is we've got a fence, we've treated it as the boundary fence, and we know that it's on the boundary and it needs repaired, and my neighbor won't repair it, won't help me with this. And so we get into that issue, and there's a process in Kansas to follow. If you can't get along with your neighbor refuses to build their portion that they're responsible for. And then tied into that question is by a crop farmer who doesn't have livestock, that their neighbor with livestock wants them to contribute toward building or maintaining a fence, and they don't want to because their crops don't have a habit and never exhibit the habit of getting up and walking away in the middle of the night. So they can't understand why they're responsible for something that they view they don't need. And so those are two big issues that I hear over and over and over again.
Now, one thing that might make that a little more confusing is that the state of Kansas is what's called a fence-in jurisdiction. Tell us what exactly this term fence-in jurisdiction means, and what that means when it comes to interpreting fence law and who needs to do what.
Yeah, and see, most people understand that, and this is why it upsets somebody that doesn't have livestock. And they say, well, it's a fence-in jurisdiction. That means if you have animals, you're responsible to put up the fence and keep them contained, keep them in. So I don't want to contribute toward any boundary fence or partition fence with you because I don't have livestock. But that's not the way that the fence-in rules are interpreted in the state of Kansas. Because that land is not used in common, in other words, there's a different usage. There's livestock on one side and there's crops on the other side. Then both parties are responsible for building and maintaining an equal share of any partition fence, a boundary fence. And that's where the confusion is, and that's where the problems arise. And so what you do in Kansas is the process to resolve that dispute, if you can't agree with your neighbor, is you call the fence viewers, which are the county commissioners. And then and that can even break down. It could be all of the commissioners. It could be any two of the commissioners. It's depending upon which county you're in and how many commissioners there are. That can also be a factor that's involved in this. So it gets pretty complex. And so once you call the fence viewers to come out, they come out and make the view, and then they decide on who's responsible for building or maintaining what portion of the fence. Now, they don't act as surveyors, so they're not going to tell you where to put that fence. That's not within their domain. But they're going to tell you who's responsible for building and maintaining a legal partition fence. And again, there's a detailed statute with what is a legal fence. So, fence law gets pretty complex.
As you mentioned, county commission not necessarily going to come in and say who builds what part of the fence. So how exactly when we talk about partition fences in equal shares, how exactly are landowners supposed to figure out what those equal shares are?
Yeah, well, that's a good question because you see, let's say you and I are adjoining property owners, and the typical rule in practice, well, it's not a rule, it's just a practice that's done, is we face each other midpoint on the fence, and I fix what's to my right, and you fix what's to your right as you face me. And so that's commonly known as the right-hand rule, and that's often utilized. Sometimes it's the left-hand rule, but most often it's the right-hand rule. And I may think, hey, that's a really good deal, because when you and I are meeting midpoint on the fence, we're at the top of a steep cliff with water down at the bottom, and to my right is flat, level pasture with no trees, no brush. This is a dream. Topsoil that's 2 feet deep, easy to put fence posts in. I'll be done with minimal cost. But we're right at the edge of a cliff when you look to your right, and you've got to go down this jagged, rocky hill or cliff, and at the bottom there's a water that you've got to fence over, and there's brush that you've got to clear to get that fence line in, and it's an absolute mess. And I say, well, have a nice day, God bless you, and you're upset about that. Well, that's meeting midpoint defense and utilizing the right-hand rule, but that's certainly not an equal share of the total cost. It's going to cost you far more. And so that's why the statute says equal share of total cost, which doesn't mean an equal allocation of length of the fence, which commonly people think that in their mind. But no, it's equal share of the total cost. And again, if you refuse to do that, there's a process for me to call the fence viewers out again to look at the problem, and then they'll tell me that through the process that I can then go ahead and build the entire fence, and they'll come back out and certify that I did it. So again, you get 3 views now, and then I can send a bill to my neighbor for half of the total cost. And if the neighbor doesn't pay that, then that can be taken to court. So there's a really detailed process. And you may think I'm making some of this stuff up in terms of how complex it is, but I'm actually kind of giving you somewhat of the facts of a case out of Riley County, North Riley County, a couple of decades ago, where we got this 3-commissioner view process: an initial view to look at the fence, a view to certify the neighbor is not participating, and then authorization of the work by the other party, and then a view that the work was done and the certification of the bill. That was all done by our courts in Kansas in setting up that process. You're not going to find that in the statute, but there's a court case on that lays all of that out. So again, pretty detailed stuff, and fence disputes can get really, really messy.
We are talking about the Kansas fence law and the various nooks and crannies associated with that. Of course, fences literally can have nooks and crannies, but even in state law, there's some provisions as to what legally is and is not a fence. Let's talk a bit about those.
Well, you're right, Kyle. We do have a rather detailed fence statute in terms of also what makes a legal fence, and certain types of fences have to be certain heights, and the wires, if it's a wire fence, certain distances apart. But we can have post and rail fences, and post and paling fences, and posts and planks and palisades, and even stone fences. There are some of those in the Flint Hills in Kansas, post and wires and turf fences, and all of those have to be at least 4 feet high. There can also be a rail fence, also known as a worm fence, that has to be at least 4 1/2 feet high at the top of the rider. There are other requirements in terms of how it's built. Stone fences, if you go with that, those have to be at least 18 inches wide at the bottom and 12 inches wide at the top. Turf fences have to be staked and ridered, have to have a ditch on the outside that's at least 2 feet wide, deep. Or 3 feet deep. Hedge fences have to be high enough and thick enough to enclose animals other than cats and dogs. And then we could just continue to go down the list in terms of the requirements for post and wires and so forth and so on. But even a brook, a river, as the statute says, a brook, a river, a creek, a ditch, or something equivalent to that can be deemed to be a legal fence if the fence viewers deem it to be a legal fence. And then, of course, the standard, the kind of the granddaddy of the fences, the barbed wire fence. It has to be at least 3 wires with a third wire from the ground not less than 44 inches nor more than 48 inches from the ground. The bottom wire is between 18 and 24 inches from the ground. The center wire is equal distance between the upper and the lower wire, and all wires have to be well stretched and barbed. And then there are requirements for the strength of the wire, how far apart you put the barbs. The wires have to be securely fastened to posts. The posts cannot be more than 2 rods apart, not less than 20 inches in the ground, so forth and so on. So again, the detail in the statute is tremendous, and the fence statute goes back into the 1800s. This is one of these that dates back to practically statehood in Kansas. So it's been pretty much left alone for a long, long time. Just minor tweaks here and there, and a few court cases that will clarify things. But that fence statute has been that way for a very long time.
Now, of course, one of the big disputes that can occur with the fence law is if, a critter gets through one side and damages the other, and there are, provisions in law with respect to the handling of trespassing animals. Let's walk through some of those.
Yeah, well, we go back to the fence-in statute on this, the fence-in theory, better said that way. And if I have animals that get out and cause my neighbor damage, then I'm going to be responsible for that. Now, if they get out through no negligence of my own and get on the road and get hit, I'm not responsible as the livestock owner. And this is another point of confusion. Kansas does not follow the rule that says that you're responsible or you have to prove that you weren't negligent. No, the injured party has to prove that you were negligent and allowing your animals to escape. And that might mean you knew you needed a stronger enclosure than what you had because you've got some animals, for example, that might be in heat. You've got that cantankerous bull that continues to get out, and you need to beef it up a little bit and strengthen your enclosure, and you didn't do that, and so that could be evidence of negligence. Or you knew they'd gotten out in the past, and you didn't remedy the problem, or you left a gate open, and the other party can prove you left a gate open, or you just didn't have an adequate enclosure. You had a bad fence and didn't get repaired. And sometimes, we have to take things into our own hands and do that. I came back from a speaking engagement one time, and I had a steer in my front yard. I thought, okay, I know where that's getting through. There's a weak point in the fence, and if you just want to deal with the problem and fix it, go fix the fence yourself, even though it's not my animal. And so I did that, and it takes care of the problem. But again, if you know you have a problem, you need to get that fence repaired. Now, if an animal kills somebody, they hit it out on the road, that's the really bad situation. And we get those cases, unfortunately, and we've got another one right now in western Kansas. The case has been filed in federal district court because of it's a diversity of jurisdiction issue. And so that'll wind its way through the courts. But, people hit a black Angus cow at night. They can't see it. We had a case a couple of years ago on I-70 out in the Goodland area. And that went through the court system, and there's still pieces of it that are out there in the court system. But in that situation, who's responsible? Well, again, the injured party, and if it's a wrongful death case, the family has to establish that the livestock owner was negligent. We don't follow the rule, like some states do, that if your animal's out, you are presumed basically to be negligent. We don't follow that rule. There are a few states that do. Nebraska has had a problem with that, but Kansas does not. Kansas rejects that theory, and the injured party or the family of the decedent has to establish that you were negligent. Another question we get on that, Kyle, related to that same question, is if it's a highway fence, say along the interstate or along a 4-lane highway, and it was the Department of Transportation's fence that caused the problem. Well, farmers and ranchers are not responsible for maintaining the highway fence. If it is a highway fence, that's the Department of Transportation's responsibility, and they have a responsibility to keep that cattle tight, so to speak. That's not a fence that's there just to restrict vehicular access to the roadway, which is what they tried to argue in one case that they lost, and they have to maintain those fences so that they will keep animals in. If animals would be up against those or enter the highway from a highway fence. So that's another point with respect to trespassing animals. And then, of course, we get the railroad fence issue. railroads are responsible for maintaining railroad fences. Now, I say that in one respect. The other respect is good luck in getting the railroad to maintain its fence. Usually what you do in those situations, you should notify the railroad if there's a problem with their fence. And the process on that is you go to the real estate office of the railroad. You find out where that local real estate office is, depending on the rail line. Now, if it's let's say you're in eastern Kansas or the eastern half of Kansas, a lot of times, let's say it's a Union Pacific rail line, that office is in Kansas City that you're going to be dealing with. But there may be other regional offices too, and also it'll depend on the rail line that you're dealing with. But what often they want to do is they don't want to deal with it, so you go ahead after visiting with the railroad, fix the fence, and then send them a bill and hope they pay it. My experience has been it's been pretty tough for a lot of landowners to deal with rail lines in getting those fences repaired and then getting paid for fixing it. So that's why I said earlier, good luck in dealing with the railroad. But there are ways to get the railroad to respond.
Now, as we mentioned, there's a lot of nooks and crannies that go with the fence law. So what resources are available for landowners to consult to determine how best to handle potential fencing situations with their neighbors or that big train coming down the line?
Well, I've got a 10-page publication on my website under my articles page that details everything that we're talking about today, plus more that we haven't gotten into, didn't have time to get into. And that's on my website. I wrote a publication for K-State a number of years ago on fence law, so a lot of what I have in my 10-page publication also is available through county extension. And so if somebody contacts K-State Extension, they'll get directed to a fence law publication that has all of these, or many of these things in it. But it'll get them started and give them an idea of what they need to do and hopefully help them get the issue resolved with their neighbor without using the court system or staying out of court with a dispute and having to hire an attorney to solve the problem for them. That's always what we want to try to do, is work things out with the neighbor first. If you can't, you go to the county commissioners. If that doesn't work, then you're going to be in the court system. But hopefully it can get resolved before that.
That is Roger McEowen of the Washburn University School of Law. He's the Kansas Farm Bureau professor of Ag Law and Taxation, visiting with us on our Ag Issues program today. Roger, thanks for joining us.
Thank you, Kyle.